Hello, 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 everybody. I don't know if I'm on time. I've been jumping my counter lately. I just got a fun little clip that I wanted to squeeze in. It was sent to me by Stanley. Thank you, Stanley. It's a judge I haven't done a video on before, Herman Marable, and it's just kind of a fun little clip. It's not too long. It's only like 10, 11 minutes long total. And it's an attorney who is asking for something that he's probably entitled to be honest. And he gets under the judge's skin, and it just gets out of hand. It's very minor. It's a tempest in a teapot. It's not a big deal, but they get real chippy with each other over like nothing. And I find it funny just because I've lived this experience many times. It's something that could be resolved, but they get a little puffed up. It's fine. It's minor, but it's amusing to watch. Let's take a look here.
Anything else for Mr. Skinner?
No, Judge. Thank you, sir.
What are the two jail files?
Okay.
Well, we got 2 jail matters, but I don't know where the jail, how they handle those.
Who's doing the jail file?
You're ready to go on the jail files,
Okay.
Katrina.
I'm missing.
Wait, she's missing one.
I'm missing Donnie Redmond.
She's missing Donnie Redmond.
Is that good there?
I bringing it down.
Okay. I'll call the jail then and see if we can get hooked up.
All right, let me call this one in the meantime. Odie Keyshawn Robbins. Got people of the State of Michigan versus Odie Keyshawn Robinson, 98598 SM. This is a motion to set aside a marijuana conviction.
Your Honor, Attorney Matthew Nord on behalf of Mr. Odie Robinson. On November 12th, of 2021, we'd filed our application to set aside this marijuana conviction. This is under the new law. The law has changed where it gives the prosecutor 60 days to respond, and if no response is done, then the law says within 21 days of that, this court must sign an order granting the marijuana set aside. This is a crime. What?
Where is your client?
My client's not here because there's no reason that we need to have a hearing. The law does not.
I want to see your client.
That's not the law. The law, we're not even supposed to have a hearing, Judge.
I want to see your client.
You need to follow the law, Judge. Sign the order. The law is clear.
And that's where we cross the Rubicon right there. I don't know. So it's a motion to set aside a marijuana conviction. For those of you who don't know, marijuana is no longer illegal in the state of Michigan. That was decriminalized a year or two ago, but it is fairly recent. Apparently part of that, and I am not familiar with this, apparently part of that is they can file these motions to set aside convictions. Okay. I don't think the judge is familiar with every provision on it because it's new and he's busy and he's got a lot of stuff going on. I suspect that the attorney is right in his statutory read of this, but he is awful. He's upset that he has to show up. I get that. I get it. But he just really takes it to the judge, and if he was a little softer, this would have gotten done. But you'll see what happens.
Tell me why I'm not allowed. Wait.
780.621E. The law says that this court must sign an order within 21 days. It doesn't say anything about having a hearing. Matter of fact, the Supreme Court Administrator's Office's application states specifically that it has under number 9, if a answer is filed by the prosecutor, which it has not, then a hearing date is scheduled then. Yes. No, and then it says after that. I'm speaking.
Okay. How would I know if the prosecutors respond? How would I know if the prosecutors responded?
Well, the same way you know if anyone responds, they file their response with the court. So it goes on to says if no answer is filed by the prosecuting agency within 60 days, that 60 days ran on January 10th of 2022, then this court must sign an order within 21 days. That 21 days ran on January 31st of 2022. It's now 2/7 of 22. This court, according to the law,
Exactly.
780.621E, must sign this order.
So did the prosecutor give you a response?
No,
And when did you serve the prosecutor?
same day.
What day was that?
November 12th of 2021.
All right, so you see the deal here. I am confident. Well, actually, I'm not confident. I'm guessing. I've never seen the provision before that this attorney has it right. And he's really irritated that it got set for a hearing because there's no need for a hearing. Having said that, from the judge's side, generally speaking, before you give a default judgment, they want to make sure that the other side was served. And you know, we get into that here. And all he wants to do is verify that. He also got entrenched in his position because this guy came at him like a bull in a china shop, which I understand. By the way, I'm not judging either of them. I could be cranky just like this judge is about it, and I could be obnoxious just like this attorney is about it if you catch me on the wrong day. I've done it. I have done it. I am not but it's funny to watch other people do it.
There's a reason they set this law up like this. So specifically, does not need to be a hearing. And there's only hearings when the prosecutor responds.
Well, I guess I need to know if the prosecutor got it.
Judge, they didn't respond. Please sign the order.
I'm gonna see if they got it. You got a problem with that?
They didn't respond, Judge. I've been on here all morning, and if no response, then yes, I do have a problem with that. That's the law says is that they.
So you would have
That is absolutely the worst thing to say. I think he's right as a matter of law. The judge is going to come around and do it. He is. You just can't push that hard. He's saying, yeah, you really irritated me and wasted my time. The judge gets all the implication of this. And if he could just tone it down a notch, he could get it done. I've been here. You have to think of your client. And I think this guy's a good attorney. I'm not knocking him too much. And this, like I said, I think this all ultimately gets done. But think of your client. He wants it set aside. Put your little patient's shoes on there and deal with it for another 5 minutes. The judge is about to roll with you, but you won't let him.
You would have a problem. You'd have a problem with me calling them to find out if they got served with your petition.
As long as I don't need to come back, that's fine.
Well, I can't address that, but
Well, there
I don't know why you have a
hearing
problem
to
with
begin with.
well, because you know what? A lot of stuff gets lost, stolen, strayed, whatever around here. If they got it and they didn't respond, then that's one thing. If they tell me they didn't get it, then we got a problem.
The law doesn't say, Your Honor, that you need to check to see if they responded. The law says if they responded or not. There's no thing in the law that says.
I think I got another petition. I think I got a petition from you of another case where the prosecuting authority did respond. The response was in the file.
That would mean they responded, Judge.
Well, I don't know if that was the city or the county, but they responded and said they had no objection. So look, you can have all the problems you want, but I'm going to see if they got it. Okay, if they got it and they didn't respond, then I guess we got to find out what's going on.
That's probably more than he necessarily has to do, but I think within his discretion. If he could have just stayed out of the way, he would have called over to the prosecutor's office. The prosecutor's office does not care. That's why they didn't respond. The prosecutor's office doesn't care. Let it happen.
Again, that's not my problem. If you want to do that, that's fine. Just let me know and sign the order, and then we'll go.
Well, I asked you if you had a problem with it, and I thought you said you did. You
I have
said
a
as long
problem
as you don't have
coming
to come
back
back.
for a
That's what you
hearing
said.
that shouldn't be scheduled to begin with. That's what I have a problem with.
Well, how would I determine if they got it or not?
The law doesn't say that the
I don't think the intention is to. I don't think the intention is for if paperwork gets lost, the judge just signs it. I don't think that's the intent. Do you?
Your Honor, the intent is that they have time to respond. If they don't, then you move forward and sign the order. That's the intent.
I got it. And if they're too busy to respond and they got it, I hear you. But if they didn't get it, that's a different matter.
Then why was this even scheduled today?
We're going to see if they got it.
Shouldn't have been scheduled for a hearing. If you're curious that they had received this or not, you could have inquired without having a hearing scheduled.
Well, other than your certificate of service, your proof of service on the scale form.
Right there, he went slightly too far. This is really inside baseball. But no, he can't just call the prosecutor's office. You need to set it for hearing. Otherwise, you're having an ex parte communication. That's why they don't do it that way. And he knows it, but he's just irritated. He's irritated because he's probably right that it should never been set for hearing. But if it is, let me tell you, I've done thousands of things like this where I know the judge is doing something that they don't necessarily have to do, but I just let it occur on behalf of my client.
That's the only thing that I know of that says that they were sent this, correct?
So in every case, do you check to see if someone doesn't respond? And every default, if the person got it or not?
Well, I'm going to tell you something, Mr. Norwood. Since the pandemic has begun, I have I have less faith in the reliability of the postal system right now to get things to people timely, to do all of those kinds of things. So
Your Honor,
Your
Honor, Mr. Skinner has a lot more he has to do. So this is what I propose. I propose you do whatever you got to do and check, and you let me know by signing the order or not signing the order. If this gets set for a hearing, it would only be because they did respond that said that they were fighting it. Otherwise,
well, again, I don't, with the pandemic, the mail, the staff shortages around here, things aren't getting into files like they used to.
And if everyone's
right.
time is at a premium, which it is, there's no reason to have a hearing for something that ain't supposed to be scheduled for a hearing. So at this time,
well, I told you, Mr. Norwood, that with the pandemic going on, the mail service, the shortage in staff, a lot of things are going on. There's paperwork that's gotten lost, or things are not getting into files. So I want to know if they got it. If they got it, then. So if you want me, I'm going to handle the jail cases. I'm going to have Katrina call Timbo Gracchus so he can check on it. We come back.
I'm not coming back, Your Honor. You let me know if you're signing it or not. Katrina can email me it. I'm not going to sit around and wait. My son's getting surgery in an hour and I got to go. So at this time, I'm leaving and you let me know what you're going to do. Katrina can email me.
Well, I won't personally let you know, but somebody will.
That's fine. Thank you.
Thank you, Secret Squirrel.
Okay. We've got 2 jail files. Katrina,
Well, I just kind of had some good fun with that. I've had 1,000 appearances like this. I've sat there while I know the result, waiting for a judge to come to the same conclusion that I know they're going to come to, and sit there with a smile on my face and just grin and bear it, because I don't want to step on the judge's toes and delay things longer. My guess, and I've never seen the statute, is that it says exactly what the attorney said, and it probably shouldn't have been set for hearing. But if the judge decides that they're going to set it for hearing, here's what the attorney is not grasping with this. You can be right as a matter of the statute, but you're not. If the judge doesn't sign the order, you don't have the order setting aside. You still need the judge to sign it. You do. I mean, do you really want to take this up on appeal and have a conviction sitting there for your client for another 2.5 years before some appellate court in Michigan remands it back to him and says, yeah, go ahead and sign the order. That's what the statute says. Really? I mean, it's not going to get there, but he is just very frustrated that this took some of his time. But he ended up taking a lot more of his time. It was clear to me the judge was headed down that path. It was just kind of fun. And I'm not really knocking the attorney. He strikes me as a really bright guy. I'm sure he's a good attorney. I think the judge is a good attorney, but he puffed up too. He wasn't going to back down after he felt disrespected by the attorney, and I don't blame him. I don't blame him. It's a good old fashioned little testosterone fueled slappy fight. That's what it was. It was kind of fun. Thank you guys for coming out. Casey Carey, $4.99. Judge needs a clean desk. Yeah, he does. He really does. But again, I'm not gonna pass judgment on that either. If it wasn't for Yesenia, my desk would be worse than that. It really would. Thank you so much. I appreciate it. I just wanted to squeeze one in here quick on Thursday. Have a good one.